Hello everyone, here we are for the second edition of Personal Injury Perspective, and we're very happy to have with us Evan Lide, who is a shareholder at the law firm of Stark & Stark, an extremely adept and experienced trial attorney. To his credit, he has gotten verdicts and settlements of over $50 million. And we're here today to speak with Evan, learn a little bit about himself, and then learn about something that's in the news currently called forced arbitration. But with that being said, welcome, Evan, to Personal Injury Perspective. Can you tell us a little bit about yourself?
Sure. Thank you so much for having me, Rob. So I'm a partner here at Stark & Stark. I've been here at Stark & Stark for about 10 years. And before I came to the firm, I worked with my dad in South Jersey and, was really fortunate to work on a lot of cases that normally young attorneys don't get to work on. But I really had a love for trying cases, and that's why I ended up at Stark & Stark, because that's what we do. We're trial attorneys here.
Evan, if I could ask you, why did you become a personal injury attorney?
I think it really comes down to helping people. I told you my dad is a lawyer. My mom's actually a school teacher. And between the two of them, I learned a love for helping people and also an appreciation of the law, which drove me to personal injury. So really, that's what we do. We meet with people when they need our help. Sometimes it's the worst day of their lives, and our job is to try to help them navigate this process to help them become compensated for the terrible loss.
So we've heard lately in the news something called a forced arbitration clause, in particular with this Disney case that is currently being broadcasted, where a woman actually lost her life. Can you tell us a little bit about that case and exactly what a forced arbitration clause is?
Sure. First, let me tell you a little bit about forced arbitration. Forced arbitration is a rigged system designed by corporations to take away your time-honored right to sue in many situations. And so forced arbitration is not a good thing at all. It is very pro-business, it's anti-consumer, and it has the effect of really stifling claims and the ability for people to be compensated, which ultimately means that wrongdoers are not held accountable in the way that they should.
So, Evan, we heard about this case that's currently in the news involving the Disney Corporation, where a woman went down to Disney and she was eating at one of the restaurants, and she actually died because she has a very severe dairy allergy. And the Disney Corporation was trying to use this forced arbitration clause to diminish her family's rights against Disney. Can you please tell us a little bit about that?
Sure. It's a very sad story. Unfortunately, this woman, she was a doctor in New York. She and her husband were down in Disney in Florida, and they were at Disney Springs at the restaurant there. They had ordered some food. This woman had a dairy allergy that was very severe. Disney has advertised to the public that if you have dairy restrictions or anything like that, they're very good about preventing exposure. And unfortunately, in this case, they did not do what they should have done because there was dairy inside this woman's food, even though she had checked and told them about this very severe dairy allergy. She consumed the food and died shortly thereafter. Her husband, as the administrator of her estate, brought forth a claim in Florida, and Disney's lawyers actually filed a motion to dismiss her claim, saying that her husband, who had purchased Disney Plus 5 years before this incident, had entered into a mandatory arbitration agreement. And so even though this had happened 5 years later, and even though that mandatory arbitration agreement was for Disney Plus, which is a streaming service, they were trying to utilize that in order to prevent her from bringing her claim, or the estate's claim, for damages.
What is a mandatory arbitration clause, and why would anybody want to enter into it?
Yeah. No one in their right mind would want to enter into one of these. And in fact, most people, when they do enter into it, they don't even know that they've entered into it. And that's one of the major problems. So a mandatory arbitration clause is, a lot of times when you sign up for a service, you're going to see the legalese. And it has different terms. It could be click wrap, text wrap. There's a number of different concepts there. But essentially, you have to scroll down and you have to assent to the terms. There are some that actually you have to go through and click through it, that you actually saw everything, and there's others that it's called browse wrap, where you can just browse to the bottom. You really don't even have to read the terms, and you can enter into an agreement with them.
So that seems really unfair that a corporation is really almost forcing you to enter into this arbitration agreement when most people don't even know what they are. I mean, what is an arbitration agreement?
Yeah. An arbitration agreement is an agreement where you have agreed to restrict your right to bring forth a case, and you're only able to do it in very limited circumstances in a forum that is typically chosen by the company that forced you to enter into the arbitration agreement. Most of the time, a lot of these go to AAA arbitration. There's no judge, there's no jury. Sometimes the rules of evidence that would apply in a court do not apply in these. And so it's a drastic change from really our Seventh Amendment constitutional right for trial by jury.
And are the arbitrators essentially picked by the corporations? And do these arbitrators understand that their job depends on returning a result that's favorable to the corporation?
As you can expect, these companies would not force you into an arbitration agreement unless it was to their benefit. And so absolutely, these arbitration forums are very pro company, anti-consumer. AAJ, which all the trial lawyers should be involved in, they took a look at this a couple years ago, and they looked at a 5-year period for mandatory arbitration clauses. And there's some really interesting data that came out of it. First of all, the scary thing is Americans are more likely to be struck by lightning than win enforced arbitration.
Wow.
That's how rigged of a system this is.
That's incredible.
So they looked at a couple different companies. For example, they looked at AT&T. AT&T has used forced arbitration during this 5-year period more than any other company in the U.S. There were nearly 1,000 consumers that were required to go through this forced arbitration process, and those 1,000 consumers, they claim more than $440 million worth of damages.
So just to be clear, the consumers had an estimate of $440 million of damages, of compensation that could have been awarded to them, but yet they somehow entered into this agreement that, what did it do?
So really what it did is it quelled their ability to recover any type of monetary damages. So that $440 million that was claimed, AT&T only paid out $376,000 worth of damages, and only 17 consumers were actually able to win a monetary award.
That is remarkable. But it begs the question, is there any way to avoid these forced arbitration clauses if you want AT&T as your telephone company, if you want to go to Disney and bring your family? Is there any way to avoid these?
There is, and really what it comes down to is you have to read the fine print. Many of these arbitration agreements will have an opt-out clause, and you just have to opt out. But the problem is when you do opt out, the terms and conditions can change, and then you may have to opt out in the future again. And really where we see this happening a lot is in the rideshare venues, with Lyft and Uber. Every single one of those companies, they have an arbitration agreement that you probably have entered into that you didn't even know that's going to affect your ability to recover if you get hurt.
So in other words, if you call on Uber or Lyft or any of the other rideshare companies and you book a ride, let's say from your home to a concert or something like that, and the driver runs a red light or runs a stop sign or rear ends someone, and you as a passenger are injured, what does this arbitration clause do to your rights to seek compensation for the injuries that you've sustained?
So the scenario that you represented just then is the scenario that we see almost every day here. Right now we have a very significant case in Middlesex County in New Jersey where our clients, they were coming back from dinner that night. They had a date night up in New York. They were coming back in South Brunswick. The Uber driver that they had hired ran a red light and hit a van full of workers going to a factory, early in the morning. And as you can imagine from this type of tumultuous collision, there were a lot of people that were injured. And my clients that were in the back seat of the Uber, when they put forth a claim against Uber and the Uber driver, the lawyers for Uber came out and said, "Nuh-uh, we have an arbitration agreement that you agreed to." And not only, it gets worse because you would think, oh, this arbitration agreement, when they signed up for the Uber app, that's how they entered into it. That isn't the case. In this case, it was actually an Uber Eats app that my client had downloaded, and we're not even sure if she's the one that actually agreed to the terms because her teenage daughter was actually utilizing the app at the same time. So it was an Uber Eats app where they had downloaded it a couple months before this incident, and they had allegedly agreed to this arbitration agreement.
So your clients obviously sustained injury. That's why they retained you. Can you tell us a little bit about the injuries that they suffered and then what this arbitration clause would force them to do?
Yeah. Unfortunately, both clients suffered very catastrophic injuries. One of my clients hasn't worked for over a year as a result of the injuries that she suffered, multiple surgeries. Her husband also had some very severe orthopedic injuries as well, but these are very significant cases. And because of the significance, the loss of wages, the medical bills, they came to see us for assistance. And when we filed the lawsuit, that's when Uber's lawyers, tried to enforce the arbitration clause. And we fought it. We're one of the first firms in New Jersey to beat the arbitration clause in a rideshare case, and I have the order here from Middlesex County from Judge Kaplan, which went through the language because what we found out was even more disturbing what Uber did in this situation.
What is that? What did you find?
So what Uber has been doing over the past couple of years is they have been fine-tuning their arbitration agreement to do just enough where they can compel the arbitration without really telling the consumer what they're giving away. And so in our case, the terms and conditions that applied in our case were terms and conditions that were sent in 2001 to our client, and it was December 16th, 2021. And those terms of conditions, they actually change from what they were a couple months before. And so a couple months before, there was a reported appellate division case, the Williams case, and in that case, the court found that the language that they used in that agreement was sufficient to advise a consumer that their trial by jury was going to be taken away from them. And there were certain words that were used that the court took a look at. And some of those words were, you're waiving the right to a trial by jury. It's using these specific terms so that the consumer can read it and see, boy, I'm really giving up my right here. And you would think that after Uber got this decision that says, yes, this agreement is good, they would continue using it. But guess what they did? They actually dialed it back, and they took out that language that notified it, and they still are trying to stick consumers with this forced arbitration clause.
That's remarkable. Why would they dial back and take out language that allowed them to win in front of a court to force an arbitration?
It's very disturbing, really, and I don't know why they did that. They haven't told us. I can only suspect that really what they're trying to do is they're trying to get people to click on it and not think and not realize that they're giving up their Seventh Amendment right to a jury trial.
And, most people, when they're going to use an Uber or a Lyft, I guess the last thing in their mind is that they're going to be involved in some type of collision or crash that will have serious detrimental effects upon them. But yet it happens a lot more than the persons believe. Is that true?
Absolutely. And unfortunately, what we also find out with these rideshare cases is, even though New Jersey has done a really good job with mandatory insurance limits, sometimes because there are so many people involved, like in the case I was just telling you out of Middlesex County, there are 4 or 5 different people that are involved that have very serious injuries. Unfortunately, one of the victims in the van that the Uber driver hit was ejected out of the vehicle and suffered catastrophic injuries. So simply the insurance coverage that they've procured for the driver isn't enough. And so really the reason why Uber and Lyft are trying to enforce these mandatory arbitration clauses is they don't want a decision that says that these Uber drivers are actually employees of Uber. And so that's what they're trying to do. They're trying to send everyone to this forced arbitration where there's no judge, there's no jury, and if they get a bad decision, no one's ever going to know about it. In Superior Court, if you get a decision, it gets uploaded and everyone knows about it. And so that's really what they're trying to prevent here.
So Evan, if you're a consumer and you want to use Uber or Lyft or any other rideshare company for that matter, what do you need to do to protect your rights so if you, God forbid, you're injured, you can go and have a jury decide your case rather than someone who is really a toady of the corporations?
Well, right now, we're really trying to improve the law here in New Jersey as it relates to that. And until we get some better decisions or until the legislature takes action, which it could, you really have to read the agreement very carefully and you have to opt out of it. However, if you do opt out of it, the company, Uber and Lyft, they can cancel the account. They could determine that if you're not going to agree to this, that you're not going to be able to use their services. That's their option. And it's a question of, are they going to do that? And so still, you should at least be aware of what you're giving up. And if you can opt out, you absolutely need to opt out. There are a lot of websites on the internet where you can Google mandatory arbitration for Uber drivers, for example. And we see this a lot in employment contexts because not only is it the victim, the passengers in the Ubers that are hurt, but there's also a lot of drivers that are hurt as well. And because Uber has decided to classify these people as independent contractors, not to benefit the driver, but to benefit the company, these drivers are really hurt as well. And so there's a lot of litigation going on right now in California where drivers are actually suing Uber and saying, we've been misclassified as independent contractors. We should be employees and we should be entitled to these great benefits that employees would normally get, workers' compensation, other benefits such as that when Uber classifies them as an independent contractor, they don't have to pay any of that.
And so you bring up another issue, I guess, apart from the arbitration agreement. Why does Uber or Lyft want to classify people that are driving for Uber or Lyft as independent contractors versus employees of the company?
Yeah, great question. And let's go back to that scenario that we have here in Middlesex County with, 4 or 5 injured people, catastrophically injured people. And under the TNC Act here in New Jersey, Uber is required to provide $1.5 million in coverage for the driver of that vehicle. But it's split among all these parties. And you would think $1.5 million, that could certainly be enough to compensate everyone. But when you think about medical bills, lost wages, it doesn't come close. And so what they're trying to do is they're trying to say, oh, well, this driver that we procured the insurance for, they're an independent contractor. And under the law, you can't sue the entity that employs an independent contractor provided that they hired someone that was competent.
So if the person is an independent contractor, can the injured consumer get to that $1.5 million in insurance coverage, or are they stuck with whatever the driver selected as his or her liability insurance coverage?
So under the TNC Act, the driver's insurance is primary, and if they don't select enough, the rideshare company is required to make sure it brings it up to those limits. And when the legislature came up with this this policy, it was a good policy. And, again, they're trying to protect as many people as they can. But really what has happened is these claims that involve, multiple people, there just isn't enough coverage. So in those situations, the injured people have to look to Uber, the company that really connected them with the driver, in order to make a claim. And what Uber is going to say is Uber says, well, we're a technology company. We're not a transportation company. You hired this independent contractor, and we've done everything we need to. We've provided up to $1.5 million, but you can't sue us directly, and that's a problem because sometimes you do need to sue the principal, Uber, directly. There have been many issues, unfortunately, with other rideshare companies, Uber, Lyft, and other ones, where they've hired a driver who has a bad record, who might have sexually assaulted someone, and that passenger is assaulted as well. And so, we really need to be able to sue Uber in those situations. And, really it's a shell game. Uber has created another LLC, Razier LLC, which pays the Uber drivers. And they say, oh, well, Uber's the technology company. Razor LLC has paid the driver. But really what we see is it's Uber that has, come up with this scheme. They're the ones that control everything. They design the app. The Uber app, they can tell where the drivers are, to this exactly where they are on the map at any point in time. They can see how fast they're going. Before, the Uber app had a couple flaws. It still has some flaws, but some of the things they've improved. But one of the problems that they had before was you could drive, over a certain amount of time, and it would still let you pick up a new ride, and that shouldn't happen. After a driver has driven for a certain amount of times, we have federal motor carrier regulations that require drivers to take a break, and that should apply to these rideshare drivers as well.
And Evan, let me ask you this. So let's say you're able to get to Uber and Lyft and to keep them in the case. And let's say you're dealing with a crash such as the one that you have right now that not only involves your clients that were passengers in the Uber vehicle, but the people that were being transported to work, you mentioned the one person was ejected. clearly $1.5 million in insurance coverage when you're dealing with catastrophic injuries, loss of income and so forth. When you're dealing with that, 1.5 million doesn't become as significant. So the question that I have for you is, if you can keep Uber and Lyft in the case, if you can keep them there, can you get beyond the $1.5 million in coverage?
So the 1.5 million applies to the driver. Uber and Lyft, they actually have separate insurance policies that cover themselves as well. And in federal court, they're required to disclose those limits. And so in state court, they don't. So that's really always the argument. And really, the goal is to try to figure out what that insurance is. And really, you have to go to a lawyer that's experienced in these rideshare cases, because the rideshare companies, the first thing they're going to do is they're going to say, look, you know, we've got the 1.5 million in coverage. Dismiss Uber, dismiss Lyft. You don't need us. And you know, of course, they want that because that's better for the company. And if your lawyer is voluntarily doing that, you know, respectfully, I think that may be a mistake. All
right, Evan. I see that we're getting close to our time here. If people want to get in touch with you, if they've been injured in an Uber or Lyft rideshare case, you clearly have significant expertise in this area. How would someone get in touch with Evan Lide?
Thanks, Rob. I've been very fortunate. I've been asked to speak around the country on these rideshare issues. Stark & Stark, we have a rideshare group here. So the best way to get in touch with us is go directly to our website, stark-stark.com. Go to the personal injury site. You can see the rideshare information there. You can reach out to me directly via the website. My name is Evan Lide, L-I-D-E, and my direct dial and my email are right on the website.
Hey, Evan, thank you so much for coming here today and giving up your time to speak with our viewers. And we really appreciate it. And ladies and gentlemen, this has been the second edition of Personal Injury Perspective. I hope that you enjoyed it and look forward to more to come. Thank you.